Hello, good evening, everyone. Okay, so my name is Amjad, and I am bringing you today's current affairs again, once again in this series. Okay, so today is 25th of November 2025. Okay, there are a few very interesting things in the newspaper today. Now, I will take up the BNSS. Okay, which has replaced the Criminal Procedures Code. Okay, then I will take up some good things about labor reforms again today in newspaper. What are the key challenges, where the issues lie? Okay, so these are the things which are there. Okay, apart from that, this is the presidential reference. Okay, again few I think conclusion article, labor reforms and presidential reference may not be in news tomorrow onwards, because some concluding points are there in the today's newspapers. Okay, then health sector issues, then Chief Justice of India, newly elected Chief Justice of India. Okay, then Trump tariffs and their impact not on the globe now. I will discuss their impact on USA now. Okay, then evolution, some small article related to Darwin's evolutionary theory. Okay, so these are the topics which I'll be taking up today. Okay, let's start first topic. The first topic is about BNSS section 356. Okay, see, I must tell you what is this BNSS section 356. But before understanding about the section 356 of BNSS, you must understand what does the BNSS stands for. It is Bharatiya Nagrik Suraksha Sanhita. Okay, BNSS stands for Bharatiya Nagrik Suraksha Sanhita. Okay, now this is a reformed version of CRPC, Criminal Procedures Code, which was the reformed version was introduced in 2023. 2023, we have brought the reformed version of Bharatiya Nyaya Sanrakshan Sanhita. Okay, now what is the reformed version and which earlier law it was there? There was one law that is called as CRPC, which was introduced in 1973. Okay, so it replaced the Criminal Procedures Code of 1973. It replaced the CRPC, Criminal Procedures Code of 1973. If you remember, in 2023, the India's whole legal system was revamped in the form of two more codes, like Indian Penal Code (IPC) was replaced by Bharatiya Nyaya Sanhita. It replaced the Indian Penal Code. Okay, it replaced Indian Penal Code. Okay, Bharatiya Nyaya Sanhita replaced the Indian Penal Code, and then there was also Bharatiya Sakshya Adhiniyam, which replaced the Indian Evidence Act. Okay, then the third one was Bharatiya Sakshya Adhiniyam 2023. It replaced the Evidence Act. Evidence Act was replaced. So this is basics about the Bharatiya Nagrik Sanrakshan Sanhita, which replaced the Criminal Procedures Code. Now, first time section 356 of this has been invoked in Delhi. What does this section 356 deal with? Okay, it allows the court to proceed with the trial of a proclaimed offender, an individual who has committed some offense, okay, and is not present before the court. In the absence of that person, section 356 allows that court may proceed in the absence of that offender. Get the point? So here it is written, section 356 of the BNSS allows the court to proceed with trial of a proclaimed offender even in their absence. Okay, even in the absence of the individual, section 356 allows that the court can proceed. Okay, so this is all you need to know about this one. Okay, now it is regarding the Jitendra Mahto case. Who who has been running after committing a murder of 68-year-old person in Delhi. Okay, now just one question, that when a person is not present, this clause is called trial in absentia. Now, there is a question that can this be processed? Isn't it the violation of right to law to be represented for the criminal? The answer is no. Why? Because he has committed a crime, he is on the run. If we will wait, आप उसके आने का इंतजार करोगे कि वो सामने आएगा तब ट्रायल करेंगे, तो वो कभी आएगा ही नहीं और कभी ट्रायल होगा ही नहीं. एक्यूज्ड के साथ इसमें इनजस्टिस हो जा सॉरी जो विक्टिम होता है उसके साथ इनजस्टिस हो जाता है. क्यों? क्योंकि ट्रायल जितना ज्यादा लंबा खींचेगा, जितना डिले होता रहेगा, सो यू माइट हैव हर्ड अबाउट अ टर्म कॉल्ड जस्टिस डिलेड इज जस्टिस डिनाइड. ठीक है, तो दिस इज वेरी वेरी इंपॉर्टेंट टू अंडरस्टैंड. ओके, नाउ द नेक्स्ट आर्टिकल, this is the article labor and owner. Okay, this again is related to labor reforms, but what I feel is that today this is now going to be the conclusion. This is now going to be the conclusion of articles regarding the labor codes as of now. Why? Because so many articles have already come up in the labor codes and labor related issues. Now what does this article says? That this article says simply what I have already told you, that labor codes have brought occupational safety, labor code have brought the concern of wages have been settled, social security has been settled, gender pay parity has been brought in. Okay, but what is the problem now? Some sections are saying that this is the biggest reform in a long time. Okay, like business community say that these are the biggest reforms. These are the biggest reforms. Okay, biggest reforms. But they say that it has been delayed for multiple reasons, their implementation. Now its success will depend upon implementation. Okay, why business community is focusing or is praising these laws? Because this will reduce compliance burden on them. They have to comply to only few norms. अब उनको कुछ norms के लिए ही compliance करना है. Earlier 29 labor related laws, huge compliance burden. Compliance burden means law को मानना और law के हिसाब से अपनी formalities को complete करना. So earlier huge compliance burden was on the business firms. Now they say that it will reduce our compliance burden every year. Get the point? Okay. Now further it has also said that most states and union territories have already published their rules or their labor codes. Now it will depend how important is their implementation. Now success of every policy depends upon the implementation. If the implementation is perfectly fine, implementation determines the success of any policy. Okay, now Indian labor system, Indian labor laws have been a hindrance for so many businesses to open and function smoothly. So it will also facilitate ease of doing business. It has also been highlighted that these laws will facilitate ease of doing business. Means government's intervention in the business hindrances will be reduced drastically. Those people who say that there must be minimal government intervention, they are called as advocates of free market. They say that market shall be as free as possible. Free market advocates. Those people who advocate, वो लोग जो ये कहते हैं कि गवर्नमेंट का कम इंटरवेंशन होना चाहिए बिजनेस में ताकि बिजनेस अपने लेवल पे फैसिलिटेट हो सके और अपने लेवल पे फ्लरिश हो सके, उनका कहना है कि फ्री मार्केट जो है दैट इज द मोर इंपॉर्टेंट. तो अब ये सिर्फ 4 लेबर कोड से इनको कंप्लाई करना मींस गवर्नमेंट का लीस्ट इंटरवेंशन, चारों में कंप्लाई करो तो दैट्स ऑल. ठीक है, उसके बाद अब हमने क्या देखा है, इकोनॉमिक सर्वे 2023-24 का रेफरेंस दिया हुआ है इसमें कि उसने कहा कि अपार्ट फ्रॉम लेबर रिफॉर्म्स व्हाट इज रिक्वायर्ड. Economic Survey 2024 says that job creation is required apart from reforms. लेबर मार्केट को रिफॉर्म करना तो ठीक है, लेकिन आपको जॉब क्रिएशन की बहुत ही ज्यादा रिक्वायरमेंट है. क्यों? बिकॉज एवरी ईयर अराउंड 12 million people are going to be out into the workforce. Workforce means working age group 15 to 59 years. Okay, every year around 12 lakh, more than 12 lakh people. 12 lakh people enter workforce every year. हर साल इतने लोग वर्कफोर्स के अंदर एंटर कर रहे हैं. इसलिए ये एस्टिमेट कर रहा है इकोनॉमिक सर्वे, वो ये क्या कह रहा है कि 78.5 लाख जॉब्स पर ईयर क्रिएट करने पड़ेंगे गवर्नमेंट को. ठीक है, किस किस में? मेनली नॉन एग्रीकल्चर सेक्टर में तो तभी इतनी वर्कफोर्स को हम क्या कर पाएंगे, एंगेज कर पाएंगे बिजनेसेस में, ठीक है। और लेबर कोड्स को क्या कहा गया कि ये जो है एक बहुत ही अच्छा रिफॉर्म है, लेकिन इसके अलावा हमको हमको जॉब क्रिएशन की भी जरूरत है, ठीक है। अब उसके अलावा क्या बात किया गया, इसमें क्या बात किया गया है, ठीक है, कि कई सारी लेबर कमीशंस जो है अभी तक सेटअप हुए हैं हमारी कंट्री के अंदर, और हमारी कंट्री के अंदर जो प्रो वर्कर रिकमेंडेशंस दी गई है लेबर कमीशंस के द्वारा, वो इसमें इग्नोर हुए। ये एक और कंसर्न बताया गया है। रिकमेंडेशन फेवरिंग वर्कर्स हैव बीन इग्नोर्ड। ये एक क्रिटिसिज्म जो है इसका फिर से आज न्यूज में आया है, ठीक है। नाउ आई होप यू विल रीड दिस आर्टिकल थॉरोली एंड यू विल गेट ईच एंड एवरी पॉइंट कि इसमें क्या क्या है, ठीक है। अब उसमें इसके अलावा गवर्नमेंट को क्या कहा गया है कि लेबर सेक्टर को और ज्यादा रिफॉर्म करने की जरूरत है। क्यों? क्योंकि गिग और प्लेटफॉर्म वर्कर्स जो आज की डेट में ज्यादा प्रेफर कर रहे लोग, क्योंकि ये हर एम्प्लॉय को, हर वर्कर को फ्रीडम देता है, ठीक है। तो अगर गिग और प्लेटफॉर्म वर्कर्स इतने ज्यादा बढ़ रहे हैं, आप देखना वर्क फ्रॉम होम, पार्ट टाइम जॉब्स ये कितनी ज्यादा इंक्रीज हो रही हैं, तो लेबर सेक्टर को इनके लाइट में, इन द लाइट ऑफ gig workers and platform workers and artificial intelligence, these disrupt the definition of work। तो वर्क क्या है, जॉब क्या है, उसका डेफिनेशन खराब हो गया। क्यों? प्लेटफॉर्म वर्कर्स, गिग वर्कर्स, इनमें ना वर्किंग आवर्स का कॉन्सेप्ट है, ना रूटीन वर्क का कॉन्सेप्ट है, डेली अवेलेबिलिटी ऑफ वर्क का कॉन्सेप्ट नहीं है, ठीक है। इसलिए इसको जो है अलग अलग तरीके से रिफॉर्म करने की और ज्यादा जरूरत है, ठीक है। और उसके बाद ये भी कहा गया है कि कई सारी चैलेंजेस है, ट्रेड डिसरप्शन, क्लाइमेटिक चेंज इश्यूज, उस चक्कर में एम्प्लॉयर और एम्प्लॉय का रिलेशन जो है उसको भी फर्दर रेगुलेट करने की जरूरत है, ठीक है। रेगुलेशन ऑफ एम्प्लॉयर एम्प्लॉय रिलेशन, ये भी एक इशू अभी भी अनएड्रेस्ड माना जा रहा है, ठीक है। रेगुलेशन ऑफ एम्प्लॉयर एम्प्लॉय रिलेशंस, एम्प्लॉयर और एम्प्लॉय के रिलेशंस का रेगुलेशन जो है वो बहुत ज्यादा स्मूथ नहीं माना जा रहा। समझ रहे हो मेरी बात को? सो दिस इज ऑल यू हैव टू अंडरस्टैंड इन द लेबर एंड ऑनर सेक्टर, ऑनर आर्टिकल ऑफ टुडेज द हिंदू न्यूज़पेपर। दिस वाज द एडिटोरियल। गेट द पॉइंट? नाउ नेक्स्ट आर्टिकल इज अबाउट द discretionary powers of governor, okay, which are there in the mentioned in article 200। now क्या ये पावर्स टोटली डिस्क्रिशनरी है? ये क्वेश्चन पूछा था किससे? जुडिशरी से। व्हाट आर दोज पावर्स? गिव द एसेंट, रिफ्यूज द एसेंट, ओके, देन सेंड द बिल फॉर रिकंसिडरेशन, और then next is reserve the bill for presidential consideration। ये ऑलरेडी हम डिस्कस कर चुके हैं आर्टिकल 200 के अंदर। और कोर्ट ने अभी अभी क्या कहा कि ये जो है ये डिस्क्रिशनरी पावर है गवर्नर की, लेकिन इसमें कोर्ट ने कॉन्सेप्ट ऑफ लिमिटेड जुडिशियल रिव्यू बताया। लिमिटेड जुडिशियल रिव्यू का मतलब क्या है कि जज क्या, गवर्नर क्या ओपिनियन लेता है, गवर्नर क्या ओपिनियन लेता है ये हमारे लिए इंपॉर्टेंट नहीं है। व्हाट ओपिनियन गवर्नर टेक्स दैट इज नॉट इंपॉर्टेंट फॉर अस, और उसमें हम जुडिशियल रिव्यू नहीं कर सकते। लेकिन अगर कोई एक्शन ही नहीं करता गवर्नर, तो उसको हम जुडिशियल रिव्यू कर सकते हैं, ओके या। सो दैट इज द कॉन्सेप्ट ऑफ लिमिटेड जुडिशियल रिव्यू, ओके। अब ये लिमिटेड जुडिशियल रिव्यू का कॉन्सेप्ट जो है ये किसने इंट्रोड्यूस किया? अगेन दिस, अभी जो प्रेसिडेंशियल रेफरेंस के लिए क्वेश्चंस गए थे, ठीक है। अब इसमें दो इसमें इंपॉर्टेंट क्वेश्चन है, मेजर दो क्वेश्चन है, ठीक है, कि ये जो डिस्क्रिशनरी पावर्स है गवर्नर के, उसमें टाइम लिमिट तो है ही नहीं, ऑलरेडी मिनिमम टाइम प्रिस्क्राइब किया है, ठीक है। एक तो ये क्वेश्चन है, ठीक है। दूसरा क्वेश्चन है कि ये डिस्क्रिशनरी पावर्स जो गवर्नर की एग्जिस्ट कर रही हैं, इनको कहां से चैलेंज किया जाए? फिर तो पूरी तरह से स्टेट गवर्नमेंट जो है वो क्या हो जाएगी? इनइफेक्टिव हो जाएगी, ठीक है। तो इसकी टाइम लिमिट भी नहीं है कि कितने टाइम में उसको ये देना है, और एक्सटेंट मतलब किस हद तक गवर्नर के पास ये पावर्स है ये भी उसमें डिफाइंड नहीं है, ठीक है। तो गवर्नर के लिए क्या कहा गया है कि इसमें कोर्ट ने ये कहा कि टाइम लिमिट के ऊपर तो हम लगाएंगे लिमिटेड जुडिशियल रिव्यू, कि अगर प्रेसिडेंट या गवर्नर इस पे काम ही नहीं करे तो हम उसको रिव्यू कर सकते हैं। एक्सटेंट में कॉन्स्टिट्यूशन ने बता दिया, या वो एसेंट दे सकता है, या वो रोक सकता है, या रिकंसिडरेशन के लिए भेज सकता है, या रिजर्व कर सकता है। तो इतने पॉइंट्स ऑलरेडी प्रेसिडेंट ने बता दिए। समझ में आ गया आपको? सो दीज आर द क्वेश्चंस व्हिच हैव बीन डिस्कस्ड हियर। यहां पे सबसे ज्यादा इंपॉर्टेंट ये बताया गया कि जो ये गवर्नर की डिस्क्रिशनरी पावर्स है ये कहां से इमिनेट होती है? दे आर इमिनेटिंग फ्रॉम वन एक्ट, दैट इज गवर्नमेंट ऑफ इंडिया एक्ट 1935। गवर्नमेंट ऑफ इंडिया एक्ट 1935, इस एक्ट से हमारे कॉन्स्टिट्यूशन का सारा स्ट्रक्चरल पार्ट लिया गया है। ठीक है, इस एक्ट में जो है सेक्शन 32 था और सेक्शन 75 था, जो किस किस के साथ डील कर रहा था? सेक्शन 32 डेल्ट विद गवर्नर जनरल एंड सेक्शन 75 डेल्ट विद गवर्नर इन द प्रोविंसेस। गवर्नर जनरल वाज फॉर ओवरऑल इंडिया एंड गवर्नर फॉर द प्रोविंसेस। ठीक है, तो इनको क्या कहा गया था कि उनको फुल पावर्स था, एक्सटेंट इसमें डिफाइंड था फुल, कि वो एसेंट दे सकते हैं, वो एसेंट विदहोल्ड भी कर सकते हैं, और वो बिल को वापस भी कर सकते हैं। ठीक है, उसके बाद इसमें 2-3 वर्ड्स थे। एक वर्ड डिस्क्रिशन था, तो ये डिस्क्रिशन वर्ड जो है वो हटा लिया गया जब कॉन्स्टिट्यूशन में आर्टिकल 200 आया। ठीक है, उसके बाद सिंगल हाउस की बात हुई कि बाइकैमरलिज्म जहां हो वहां पे नहीं हो सकता, जहां पे वन हाउस हो, सिंगल हाउस। कौन? सिंगल हाउस मींस यूनिकैमरलिज्म। वो स्टेट लेजिस्लेचर जिनमें एक ही हाउस होता है उसको क्या कहते हैं? यूनिकैमरल लेजिस्लेचर। तो सिंगल हाउस वाला जो कॉन्सेप्ट है वो भी ड्रॉप कर दिया गया वहां से, क्योंकि कुछ स्टेट्स आज की डेट में हमारी ऐसी हैं जिनके पास 2 हाउसेस है, कुछ स्टेट्स ऐसी है जिनके पास एक ही हाउस है। तो अगर आप सिंगल हाउस वाला कॉन्सेप्ट की सिंगल हाउस में डिस्क्रिशन है गवर्नर को, तो इसका मतलब आप इंटरस्टेट ही इनइक्वालिटी क्रिएट कर रहे हो। ठीक है, उसके बाद मेन जो मुद्दा है इसमें, ये तो ऑलरेडी हमने बातें की हुई है, इसलिए ये मैं मिटा सकता हूं ताकि मैं आपको दूसरी चीजें यहां पे और बता सकूं। यहां पे इस आर्टिकल में एक इंपॉर्टेंट रेफरेंस दिया गया है कि हमारे पास 3 कमीशंस बैठी हैं आज तक सेंटर स्टेट रिलेशंस के ऊपर, डिफरेंट डिफरेंट टाइम पीरियड्स पे। हर एक कमीशन ने एक अलग रिकमेंडेशन दिया है। ठीक है, जिसमें जो 3 कमीशंस हैं, जिसमें सरकारिया कमीशन है, सॉरी, देयर आर 3 कमीशन सो फॉर जिन्होंने सेंटर स्टेट रिलेशंस के ऊपर जजमेंट्स दी है। द फर्स्ट वन वाज सरकारिया कमीशन। सरकारिया कमीशन 1988 आई गेस, या 1988 सरकारिया कमीशन। ओके, 2002 पुंछी कमीशन, पुंछी कमीशन, एंड then there was also one more commission, sorry, 2010 पुंछी कमीशन 2010, एंड 2002 में सेपरेट कमीशन। हाँ, 2002 इट वाज वेंकटचलैया कमीशन, वेंकटचलैया कमीशन। These 3 commissions always gave recommendations that the governor, appointment of governor is by default a faulty process. Means center has absolute powers in terms of appointment of governors, which is not a correct practice. Okay, now Sarkaria Commission gave 2 recommendations. Sarkaria Commission says that governor should be outsider. This we have adopted. Usually the governors are outsiders. This one we have adopted. Moreover, it says that whenever we have to appoint a governor, CM must, Chief Minister of the state must be consulted. So it recommended Chief Minister consultation. But center does not do any consultation with the chief ministers when they appoint governors. Okay, then Venkatchalaya Commission and Punchi Commission have made very good recommendations. They have said that a committee must be formed for appointment of governors. The committee must include Prime Minister, then Union Home Minister, then Speaker of Lok Sabha, and then Chief Minister of concerned state. this committee must give recommendations, or this committee must make the appointment of governors. Then there will be improvement in the relations of governor as well as the state legislature. This is the best part which I have found in this article. Okay, although the details of these commissions have not been given. Now we had one Attorney General of India, a very intelligent jurist. His name is Soli Sorabji. Okay, Soli Sorabji. Okay, now Soli Sorabji has said that there is an unhealthy practice that those people who get defeated in election, mostly the posts of governors are given to them, or influential individuals or retiring bureaucrats are handed over the position of governor. This practice shall be done away with, and there shall be a properly meaningful process of appointment of governors to improve the relations between governor and the center-state relations. Get the point? So, no, sorry, not center-state relation between legislature as well as the executive, state legislature and the executive. Okay. Now, this is all you must understand what has been given in the article. Okay. Next thing. World Health Organization has removed some data which gives some insights about health sector in India. Now, this report has given this data, World Health Organization's data has shown some issues with different parts of the globe. Okay, first of all, one is doctor-patient ratio. Doctor-patient ratio. Usually, nobody has said what it should be. We follow just one general guideline. That was not a rule. That was not a law made by World Health Organization that there shall be one doctor per 1,000 patients or per 1,000 people. One doctor per 1,000 people. Doctor-patient ratio. But do we have the doctor-patient ratio in India? 1,000. Now, in India, what is the ratio? The ratio is currently in 2024, 836 doctors per patient. 836 per one doctor per 836 patients. Okay, one doctor per 836 patients. Now we'll be happy that our ratio is good and it is near to the World Health Organization guidelines. But I must tell you that it includes the Ayush doctors as well. Which means if you exclude the Ayush doctors, then there is one doctor per 1,262 patients. 1,262 patients, we have one doctor, which is not actually a suitable number. Means doctor deficiency has been highlighted in this first one chart. Okay, now if I go by chart 2, it says that this chart number 3, it says that and what is the global average? Globally, we have approximately more than 1,000 doctors per patient, more than 1,000 patients per doctor. Okay, now second is the doctors and paramedical staff. Doctors and paramedical staff. Paramedical staff means nurses, staff nurses, midwives. Okay, get the point. So it is basically how much we have for India. For India, it has said that we have 3.6 per 1,000 figure. Okay, 3.06 per 1,000 means 3.06 doctors and paramedical staff is available for 1,000 patients. Is it sufficient? Global average says that globally we have 4.45. Okay, it is far much below the global average. Globally 4.05 doctor and paramedical staff are available per 1,000, but in India only 3. Means we need to empower, we need to enhance our paramedical staff also. Even these Asha workers are to be trained to deal with health related issues. Okay. Now, if we see rank of India in terms of doctors, we are 118 out of 186 countries. Rank of India in doctor population ratio. And in doctor and paramedical staff population ratio, India is ranking how much? India is ranking how much? In paramedical staff, 112 or 122 out of 186 countries. This both the figures highlight shortage of staff in trained in medical sciences in India. Trained in medical sciences in India. So this is all given in this charts. So from here, 2 points for your mains examination in health sector. One is I'm highlighting it here. One is poor doctor to patient ratio. Poor doctor to patient ratio. And second, poor doctor and paramedical staff to population ratio. These are the two main difficulties which India is currently facing in the health sector. Next article also highlights that we have so many other challenges in the health sector. That is particularly a case study from Maharashtra, this one. Okay, why infant deaths are taking more place in tribal dominated Malghat region in Maharashtra. Malghat is a part of Amravati district in Maharashtra, and here mainly which tribals live? The Korku tribals live here. Korku tribals. Okay. What is the problem among the Korku tribals or Korku tribe people? That children before attaining the age of 1 year are dying. Okay. So there is basically infant mortality rate is higher. Infant mortality rate is higher. What is infant mortality rate? It is number of children dying before attaining the age of 1 year per 1000 live births. Okay. Children deaths per 1000 live births. In 1000 live births, how many children are dying? Okay. Across pan-India level, the infant mortality rate, I am here writing, infant mortality rate of India is around 25 to 27 per 1000. Means 1000 live births, 25 to 27 children are dying before attaining the age of how much? Age of 1 year. Now, what are the problems? Bombay High Court has said to the government of Maharashtra that you are having extremely casual approach towards this issue. Because if you see, 96 infants have died in 1 year in Maharashtra. Okay, and 61 children have died only in the past 7 months. Okay, now what are the problems? Main problems. The main problems are, number one, malnutrition. Malnutrition means ample calories are not available with the children. Then anemia. Anemia means blood deficiency. Then sickle cell disease. Sickle cell means red blood cells or deformities are found in the red blood cells. If the normal shape of red blood cells is like this, then because of the deformity, they attain the shape of sickle cell anemia. Okay, so then also pneumonia, then also delays in treatment and lack of connectivity. These are the major issues which have been highlighted. Okay, now it has been also highlighted, Maharashtra's Women and Child Welfare Department says that 1.8 lakh children are malnourished in Maharashtra only. This is the figure from one state. Can you imagine the issue across whole the country? And moreover, within 35% of children under 5 are stunted and 35% are underweight. What do you mean by stunted children? Stunted children means those children which have low height to weight. As compared to weight, their height is low. Means as compared to their weight, their height is low. This is called as child stunting. Now, in the child stunting, what we have found, low height for their age. So not height, weight, it is for age. Low height for the age. Means age is increasing but height is not increasing. And this shows, child stunting shows that there is chronic, long-term undernourishment. More stunted children means chronic undernourishment. Chronic undernutrition. Chronic undernutrition is highlighted by more stunted children, means their height is not growing with their age. Okay, and underweight children are how much? 35%. Now it is called as child wasting. Child wasting means children who are having proper height but yet their weight is not gaining. Okay, so that is called wasting. So wasting and stunting both are parameters of global hunger index also. So poor performance of Maharashtra on global hunger index. Okay, then also infant mortality rate, which is a key indicator of child health, has improved in Malghat from to 16.5, while Maharashtra's infant mortality is 15 as the sample registration. Okay, now what are the remedial measures? They are highlighted in this part of the article. They say that first of all we have to remove malnutrition, and then we have to create a healthcare system in which transportation facilities are available, nutritional facilities are available. Midday meal scheme only is not sufficient. Midday meal scheme, one time a meal in a day, that too on the working days. What about the leave period? What about those period when there are examinations? Okay, ASHA workers should get very proper training also. Then also there shall also be allied disease. They shall be treated equally, and then also community centered behavioral change shall be promoted, and civil and health infrastructure shall be improved. So these two articles from The Hindu explain that there are so many issues in the health sector in India. Okay, now next point. Next point, Justice Suryakant takes oath as 53rd Chief Justice of India. Okay, Chief Justice of India, the apex most judicial functionary in the country. Chief Justice of India, 53rd Chief Justice of India, we follow seniority principle, which is a convention. Not a law. Seniority principle is a convention because it has been violated so many times, 2-3 times at least. Okay, Justice M. Hidayatullah was posted without having seniority, superseding 2 senior judges. Okay, now we see this appointment of judges is a question which has been there in news. Okay, now who does the appointment? First of all, the recommendation, outgoing Chief Justice of India sends recommendation to Ministry of Law. Union Ministry of Law gets recommendation from the Chief Justice of India. Now, after Ministry of Law gets the recommendation, then it gets approval from Prime Minister. Okay, fine, it is okay. Approval from Prime Minister. And then finally, the appointment is done by President. Now, which article of the Constitution deal with appointment procedure? Article 124, Clause 2 of the Constitution deal with appointment of judges. Article 124, Clause 2 deal with appointment of Chief Justice of India. Okay. Now, in the same way, in India, appointment of judges is a big question, because if you see, till recent times, the judicial appointments were not taking place, and in Supreme Court only in 2024 all the 34 judges have been in place. In Supreme Court we have a strength of total 34 judges. They were in place. Okay, now which system we follow for appointment of judges? That is called collegium system. In collegium system we form a body called collegium. For Supreme Court judges it is different. And for High Court judges the collegium system is different. Okay. For Supreme Court judges, the collegium is Chief Justice of India plus 2 plus 4 senior most Supreme Court judges. For High Court judges, the collegium is Chief Justice of High Court plus 2 senior most judges. 2 senior most judges of High Court. Get the point? So this is the collegium system. Now, President has to consult the collegium. President has to consult the collegium before making the appointments. This consultation was questioned. Ki whatever the recommendation is given by the collegium, is it binding on President or is it not binding on President? So therefore, there are cases. One is called first judge's case. First judge's case. Case related to judges. Then there is second judge's case. And then there is third judge's case. Third judge's case. In all the three judges' case, there is evolution of the appointment of judges. Appointment of judges. Okay. Now, in the first judge's case, Supreme Court says that consultation does not means concurrence. The word consultation does not means concurrence. Means the consultation is not binding for the President. Consultation does not means concurrence. This judgment was given by Supreme Court in 1981, that when you have to consult judges, collegium, the opinion of the judges, plurality of judges is not important. In the second judge's case, Supreme Court overturned the judgment in 1993. Second judge's case, 1993, Supreme Court said consultation. When President consults, then it means concurrence. When President consults, it means concurrence. President has to obey. Finally, in the third judge's case, Supreme Court said that consultation not only from Chief Justice of India, but from other judges also. So third judge's case, plurality of judges means 4 Supreme Court senior most judges. Plurality of judges for consultation. So over a period of so many years, ranging from 1981 to 1998 was the third judge's case. Okay. Finally, Parliament in 2013 passed an act that is called as National Judicial Appointments Commission. That judicial functionaries will be appointed by the National Judicial Appointments Commission. But in fourth judge's case of 2015, this National Judicial Appointment Commission was declared invalid by the Supreme Court. Get the point? Okay. Now, this collegium system has been criticized for various issues. Like there is no transparency, who are the senior judges, no publication of the list. Then there is huge scope of nepotism also. Then there is also no role of executive in the appointment of judges. And there is basically no predetermined procedure for appointment. Just the seniority principle is being followed across the country. Seniority principle only is being followed across the country. That's the point. So this was appointment of judges. Here, the recently Chief Justice appointed Justice Suryakant has highlighted one important issue. The first priority will be to clear 90,000 cases which are pending in the judiciary. So in Supreme Court also 90,000 cases are pending at the Supreme Court in different branches. So he has highlighted the emergency of clearing the pendency of these cases. This is all you must understand. This is what it has been highlighted. Okay. Now, Trump tariffs. I'll discuss Trump tariffs. Trump tariffs not only harmed different countries across the world, they have harmed the USA also. Okay, now please understand how tariffs have harmed the USA. Okay, because of increasing the tariffs, costs of products will grow up. Because of increasing cost of production, one issue will happen, that is called inflation. Rising cost in the economy of the various different products, it is called inflation. What is this graph highlighting? This graph has highlighted that inflation has increased over a period of time. April 2025, this is the point inflation was. Okay, it was around 2.3%. Inflation 2.3% in April 2025, America. Okay, now in the month of September, it has gone up to 3. It has gone up to 3. Inflation has gone up to how much? 3%. Okay, now inflation in September, it is 3%. So why inflation? Because cost of production cost of the products has increased because of the high tariffs. So why cost of products? Because and moreover, who pays for the tariffs? It is not that India is exporting commodities and India will pay. First, India will pay, definitely. But when the commodity reaches America, the consumer of America purchases, consumer pays. So import duty is also an indirect taxes. Okay, so indirect tax on customers. Okay, now because of huge tariffs, things may become costly, that may reduce demand. Which may reduce production. When production may reduce, this may increase unemployment, because if production is not there, why people will be on jobs? It may increase unemployment also. Okay, how it may increase unemployment, we have also seen in April, in the month of April, unemployment was at 4.2. In the month of August, unemployment was at 4.3. So it has gone up from 4.2% to 4.3% unemployment rate in America after implementation of the tariffs. Get the point? Okay, and also consumer sentiments have also declined over a period of time because of the Trump tariffs. So it means this article highlights, this is from Indian Express, that Trump tariffs this was basically it was basically a faulty decision. It was faulty decision because not only the countries across the world have faced the problems, but domestic economy of USA has also faced the problem. That's why they call it flawed economic logic. Flawed economic logic. Flawed economic logic. Flawed economic logic. Okay, so this is what has been shown in the this article. Okay, on Trump tariffs. Okay, now last one more article remaining.
Sorry, there is a problem with Apple Music. You need to log into your music account again to start playing.
Okay, I have heard. Can you please shut up now? Okay, yeah, please. So the next thing, which is related to evolution, an article related to evolution related to Darwin. Okay, how Darwin's Origin of Species laid basis for modern day evolutionary theory. Now you will say that it is such an old thing. Charles Robert Darwin, his theory of evolution, a very old thing. Why is it today we are going to discuss it? Because on the same day, because on November 2024, November 24, because on 24th of November 1859, Darwin's book was published. Which book? It is On the Origin of Species. On the Origin of Species. In short form, it is called Origin of Species. Okay. This book, a landmark book to study evolution of humans mainly. Almost all the organisms evolution has been studied, but Origin of Species particularly was helpful in studying human evolution. Okay, they say that humans have evolved over a period of time because of one phenomena which Darwin calls as natural selection. Natural selection. Like UPSC selects the UPSC aspirants, nature selects the members who are going to survive. And natural selection is done on the basis of fitness. Okay, fitness means how much fit you are and how easily you are adapting to the changing nature of the environment. Darwin in Origin of Species says that human beings, organisms, life forms on the earth are growing, but resources are not growing at that pace. So therefore there is a struggle within the species and among different species, interspecific and intraspecific struggle. And then because of the struggle that he calls struggle for existence, struggle for existence, because of that struggle, finally the fittest will survive. Who are the fittest? Who will show great adaptations, who will change as per the needs of the time. Okay, so adaptations, those who will show adaptations. Okay, it was Herbert Spencer who used the phrase survival of the fittest here. Herbert Spencer, survival of the fittest. Moreover, it was T.H. Huxley, Thomas Henry Huxley, who popularized the Darwin's theory of evolution and coined the term Darwinism. Thomas Henry Huxley coined the term Darwinism. Okay. Now this Darwin's theory of evolution, particularly the survival of the fittest, applies to UPSC aspirants also, civil services exam aspirants also, because those people who are able to evolve their answer writing every day by writing good answer, practice hard and get clarity and get so much precision on optional subject, then only they will get selected in the final exam. So there is a struggle among all the competitors, but only those who will be fit for the selection, they will be selected. Now what is the fitness criteria? Fitness for the civil services aspirant, I may call it the UPSC fitness or civil services exam fitness. Okay, first of all, discipline, then updation, current affairs updation, then practice, MCQs, mains answer writing, and imbibing great personality traits, that is called as officer-like qualities. Okay, that is personality development. So these are the fitness criteria. Please understand, I have never mentioned here that you must have this much biceps, this much triceps, you must have this weight and this height. No, only this is the UPSC fitness criteria for civil services aspirants. So follow all these criteria, you'll find yourself in final list of the selection. Okay, so this is all for today in the current affairs. Okay, thank you so much all of you. We will meet again tomorrow with another bunch of current affairs on the basis of tomorrow's newspaper. Thank you.